I address you at a moment unprecedented in the history of the Union. Hitler was on the march.
A new bill the governor calls the strongest Second Amendment legislation in Texas history is awaiting his signature.
Bans dozens of specific types of rifles and handguns, 50 caliber guns, attachments, rapid firing devices.
While concealed carry laws, also known as CCWs in California, aren't instantly nullified by the
Supreme Court in the last couple of hours, which has ruled that Americans do have a fundamental right to carry firearms in public.
Attack arm bans. The Supreme Court is currently considering a significant case regarding attack arm bans, specifically the case of Bianchi versus Maryland. This case has garnered attention due to its implications for arm rights and Second Amendment protections. The initial challenge to Maryland's attack arm ban was brought forth by the Second Amendment Foundation and Arms Policy Coalition. It follows previous legal battles, including the Clayman versus Hogan case, which saw a district court ruling the attack arm ban unconstitutional, only to be overturned by the Fourth Circuit Court of Appeals. The Bianchi case gained further traction after the Supreme Court vacated and remanded a similar case, Bruin versus City of New York, prompting renewed scrutiny of Maryland's ban in light of the Bruin decision.
I address you at a moment unprecedented in the history of the Union. Hitler was on the march.
Bans dozens of specific types of rifles and handguns, 50 caliber guns, attachments, rapid firing devices.
Well, I did do something by establishing the first ever Office of Gun Violence Prevention in the White House that the Vice President is leading the charge.
With legal staff as well as legislative leadership to ready and craft legislation that will be heard next week.
However, despite the Supreme Court's directive, the Fourth Circuit Court of Appeals has yet to render a decision on Bianchi, prompting concerns about judicial delay and avoidance of addressing Second Amendment issues. The crux of the Bianchi case revolves around whether the government has the constitutional authority to prohibit law-abiding citizens from possessing semi-auto rifles commonly used for lawful purposes such as self-defense, hunting, and target shooting. The petitioners argue that the Second Amendment protects individuals' rights to own and use arms that are in common use for lawful purposes, such as semi-auto rifles like the AR-15. They contend that Maryland's ban on semi-automatic rifles infringes upon this constitutional right, citing Supreme Court precedent, including District of Columbia versus Heller, which affirmed the individual right to bear arms for self-defense. The petitioners argue that the Heller decision established that arms commonly possessed by law-abiding citizens are protected under the Second Amendment and cannot be subject to outright bans. The petitioners further assert that modern semi-auto rifles like the AR-15 have become widely accepted and are owned by millions of Americans for lawful purposes. Therefore, any ban on these arms would constitute a violation of Second Amendment protections. The case also highlights concerns about judicial interpretation and adherence to Supreme Court precedent. The petitioners criticize lower courts, particularly the Fourth Circuit, for failing to properly apply the principles established in the Heller and Bruin decisions. They argue that lower courts have been inconsistent in their interpretation of Second Amendment rights, leading to confusion and conflicting rulings. Additionally, the petitioners raise questions about the motives behind the Fourth Circuit's delay in issuing a decision on Bianchi. They suggest that the court may be attempting to avoid ruling on the case or seeking to circumvent the Supreme Court's directive to reconsider the ban in light of the Bruin decision. The Bianchi case represents a significant legal battle over arm rights and the scope of Second Amendment protections. The outcome of this case could have far-reaching implications for arm laws nationwide, particularly in states with attack arm bans. As the Supreme Court considers whether to grant review of the case, the debate over arm rights and regulation continues to be a contentious and highly polarizing issue in American society. Second Amendment and concealed carry. The issue of concealed carry and its alignment with the Second Amendment rights has resurfaced in front of the Supreme Court, prompted by New York's ongoing defiance of the landmark Bruin decision. Just 8 days after the Supreme Court's 6-3 ruling in New York State Rifle and Pistol Association versus Bruin, New York passed the Concealed Carry Improvement Act, introducing a hyper-restrictive concealed carry law. This act contradicted the essence of the Bruin decision which invalidated New York's previous concealed carry laws. Gun Owners of America petitioned the Supreme Court to review New York's defiance and strike down the CCIA, arguing that it violates the Second Amendment. Bruen emphasized that the government must demonstrate that its restrictions on arms are rooted in the historical tradition of the nation, dating back to 1791, the year of the Second Amendment's ratification. However, New York's rush to pass the CCIA disregarded this requirement, enacting even stricter regulations than those invalidated by Bruen.
Some precedent moment in the history of the Union. And yes, my purpose tonight is to wake up the Congress.
Need the gun for self-defense. She said the court broadened gun rights beyond what many experts expected.
While concealed carry laws, also known as CCWs in California, aren't instantly nullified by the appended.
Stop it, stop it, stop it.
Several cases challenging the CCIA were expedited for review by the Second Circuit Court of Appeals in response to warnings from the Supreme Court. These cases tackled various aspects of the CCIA, including concealed carry restrictions on private property, at places of worship, and its impact on armed dealers. However, the Second Circuit's ruling vacated many of the district court's injunctions against the CCIA, deeming most of its provisions constitutionally sound under the Second Amendment. GOA filed a petition for Supreme Court review, highlighting the divergence among lower courts regarding historical evidence justifying arm regulations. The petition underscores the Second Circuit's reliance on mid to late 19th century laws, disregarding the historical tradition dating back to 1791. This selective historical analysis has become a tactic used by anti-arms states to justify their restrictions, bypassing the standards set by the Bruen decision. The Supreme Court's order denied GOA's emergency application for relief, but urged the Second Circuit to address the issue promptly. In response, the Second Circuit expedited hearings on the CCIA challenges, leading to 5 rulings on different cases. However, these rulings continued to uphold the constitutionality of the CCIA, despite its inconsistency with the Bruen decision. GOA's petition argues that the Second Circuit's defiance of the Bruen decision sets a dangerous precedent for Second Amendment rights nationwide. By circumventing the historical standards established in Bruen, the Second Circuit effectively undermines the fundamental right to bear arms. The petition calls for Supreme Court intervention to resolve the debate between historical evidence from 1791 and 1868, emphasizing the need for consistency in interpreting Second Amendment protections. The outcome of GOA's petition is critical not only for New York, but also for other states facing similar challenges to their arm regulations. The debate over historical evidence shapes the legal landscape for Second Amendment cases across the country. As the Ninth Circuit deliberates on California's concealed carry ban, the precedent set by the Supreme Court in response to GOA's petition will influence future rulings on arm rights. The Supreme Court's consideration of GOA's petition reflects the ongoing struggle to uphold Second Amendment protections amidst state-level defiance and judicial interpretation. The outcome of this case will have far-reaching implications for concealed carry laws and arm regulations nationwide, shaping the future of Second Amendment jurisprudence in the U.S. Biden's arm violence strategy. President Biden's recent State of the Union address underscored his administration's robust strategy to combat arm violence in the U.S. Central to this strategy is the allocation of $350 billion from the American Rescue Plan to support cities, counties, and states in hiring more police officers and implementing community violence intervention programs. The president highlighted executive actions aimed at addressing the proliferation of ghost arms and reiterated the urgent need for congressional action to address the ongoing epidemic of armed violence, which claims over 100 lives daily.
A new bill the governor calls the strongest Second Amendment legislation in Texas history is awaiting his signature.
That this was no ordinary time. Freedom and democracy were under assault in the world.
Supreme Court in the last couple of hours, which has ruled that Americans do have a fundamental right to carry firearms in public.
The administration's comprehensive approach to reducing armed crime focuses on 5 key components. Firstly, efforts are directed towards stemming the flow of arms used in violent crimes. Secondly, support is provided to local law enforcement agencies through federal resources to enhance community policing and combat violent crime effectively. Thirdly, investments are made in evidence-based community violence interventions to address root causes of violence. Initiatives are underway to expand summer programming, employment opportunities, and other support services for teenagers and young adults, offering alternatives to involvement in criminal activities. Additionally, efforts are made to facilitate the successful reintegration of formerly incarcerated individuals into their communities, thereby reducing recidivism rates. Significant progress has already been achieved through the implementation of these strategies. A bipartisan investment has been secured to combat armed crime, including funding for community violence interventions and resources for law enforcement agencies. The American Rescue Plan funds have been utilized by cities and states to address armed violence effectively. Regulatory measures have been initiated by the Justice Department to regulate the proliferation of ghost arms, and law enforcement strike forces have been established to address arms trafficking, particularly along the iron pipeline. Additionally, states like Connecticut and Illinois have enacted legislation allowing Medicaid reimbursement for hospital-based armed violence prevention services, facilitated by actions from the U.S. Department of Health and Human Services. The success of these efforts is attributed to the dedicated armed violence prevention team at the White House, led by Domestic Policy Advisor Susan Rice. This interdisciplinary team, consisting of experts in criminal justice reform, racial justice, and public safety, collaborates closely to advance the administration's armed violence reduction agenda. That's all for this video, folks. See you next time.